Welcome back to the Southern Scene on WSAV. It's now time for our legal scene. You know, we all get injured or become sick at some point in our lives and have to receive treatment from a physician or in a medical facility. But what happens when that treatment you received is considered negligent? Well, that's what we're going to focus on today when we talk to our legal expert, Mark Tate, as we talk about medical malpractice. Mark now joins us from Tate Law Group. Mark,
let's talk about medical malpractice. What is medical malpractice?
Yeah, this is a question we get a lot. A lot of folks call the office. We get dozens of calls a day about people mad about something that happened in a doctor's office or a hospital. And so we have to start out by telling them.
You represent a lot of clients with all of that.
We do. And, you know, we also represent a number of doctors, and I'll explain that too. But medical malpractice in Georgia and nationally is defined as what an ordinarily skilled doctor would do under similar conditions and like surrounding circumstances. And you're not entitled to good care. You're only entitled to ordinary care. And a doctor is presumed to have rendered you ordinary care. And so just because something went wrong does not make something medical malpractice. In order for there to be medical malpractice, there has to be what's called a deviation or a failure to meet the standard of care.
Give me some of those common examples of medical malpractice. Can you give
me?
Well,
we hear the horror stories all the time. Wrong limb amputations, and that's actually a very common mistake that's made, is that people go in and operate on the wrong limb. But really, the more common complaints we get are just routine problems that people have with doctors in their offices and hospitals. We don't take those cases. We can't afford to take the cases. And so most of the time, unless you have a gainfully employed adult who has been disabled from earning a living or killed with dependent spouses and children, in Georgia, lawyers really don't take those cases because we've had a massive change and overhaul in 2005 of Georgia medical malpractice law. And so
most of these cases, are they settled, or do most of them go to court?
98% of every single civil case ever filed does settle before trial. Medical malpractice presents us a different picture. In medical malpractice cases, there are disincentives to a medical doctor settling. If a medical doctor settles his or her case against him, then they go into what's known as the National Practitioners Database, and they have that, asterisk next to their name that they've settled a medical malpractice case. But most cases in medical malpractice do settle. Some go to trial. The ones that go to trial, most of them are defense verdicts. And the reason for that is complex, but it starts with this. Just about every medical doctor in Georgia is insured by the same medical malpractice insurance company. It's called MAG Mutual. MAG Mutual insures most of these doctors. They hire the lawyers who represent and defend the doctors. Mm-hmm. And so a lawyer who represents doctors has the unbelievable advantage of being able to pick up the phone and for free talk to just about any doctor in Georgia about a case and find experts in Georgia to come in and testify for another doctor. It's difficult and very costly and time-consuming for a plaintiff's lawyer like me to find somebody who's willing to testify against a doctor.
But now, can you have a malpractice case not only against a physician, but a medical facility?
We're involved in one right now against Memorial. When the hospital negligently credentials a physician and gives them the ability to treat patients, they can be responsible for what that doctor does wrong. Negligent credentialing would be, for example, failing to pick up the phone and make a phone call to his prior employers and say, hey, is he a problem? Is he cutting off the wrong limbs? Is he addicting his patients?
But isn't it hard to sue a medical facility? I mean, they're huge.
You have to be smart and able to finance your case to win, and you have to have a great case. But no, it's not hard to sue them, but it's hard to be right and win.
When you go and you receive treatment in a medical facility or from a physician, I mean, you sign all kinds of paperwork.
Yeah.
When you sign all of that, does that waive your right
No, absolutely
to sue somebody later if something happens?
No, absolutely not. No, what you're signing is you're signing that you understand that there are risks and things that can happen to you when the procedure that you're undergoing is done with ordinary care. You are never consenting to be treated intentionally wrongly, and you're never consenting to the consequences of negligence.
If someone needs a malpractice attorney, what is something that they, I mean, what should they look for?
Well, if I was going about to hire any kind of lawyer, I would want to know, do you have a conflict, first of all? Is it going to bother you to sue this doctor if they did something wrong? You want to find out if that if that lawyer has a way to get experts that you need. Has that lawyer filed a medical malpractice case before? Is he going to keep it in his office, or is he going to give it away to another lawyer to handle? Things you want to know, and you need to feel comfortable.
So you guys handle a lot of these cases. So why should someone choose Tate Law Group?
Well, we have a medical staff here that we review cases with. We have a staff of registered nurses who assist us. As I've said, we do a lot of pharmaceutical litigation, and we rely on medical doctors to help us understand what's wrong with medical products. And so we have good contacts in the medical community. Last thing we ever do with a client is have them come in and think that they're going to win a case. And so we need to be able to tell you very quickly whether the case that you brought to us is something we can win. And if we can't, we're not going to take your case, because I'm not going to build up your hopes, and I'm not going to spend our time and money, because the last thing that a lot of people don't understand is that when you bring us a case, we take it on a contingent fee. We are working for nothing the entire time of your case.
And you don't get paid unless
And we don't get paid unless we win. And more than that, there are expenses incurred in litigation. And a medical malpractice case can cost $100,000 to get to trial or more. We want to make sure that if we're spending our money, we're going to make a difference for you. And if we're not, we can't take your case.
Okay, thanks a lot, Mark, for
Thank
joining
you.
us.
If you have a legal question for our legal expert, Mark Tate, for the legal scene on the Southern Scene, all you have to do is send us a message on our Facebook page or our website. You'll find that information right there on your screen. We'll get those legal questions answered for you. Don't go away. We'll be back with more of the Southern Scene right after this. Stay with us.